the Young Lawyers Conference. Technically represents Winchester, but now he is here with us down in Virginia Beach and in Norfolk. So he graduated from William & Mary in 2010, and he got his JD from Washington and Lee, and he's a member of the bars of Virginia and West Virginia, and was an associate at Lawson & Sillick in Winchester for the past 3 years. And now he clerks for, I believe it's a federal judge? Justice of the Supreme Court, Justice Goodwin. Yes. He is a member of the Board of Governors with us and now serves, I should have kept reading, as a law clerk for Justice S. Bernard Goodwin of the Supreme Court of Virginia. Chris, the floor is yours.
All right, let's see if we can get this thing going. And first of all, I have to thank Rachel and everyone else who put this program together. I think it's a great opportunity for young lawyers to get CLE experience from other young lawyers, so that's kind of fun. Disclaimer, obviously, since I am in a room full of lawyers, I feel like I ought to say this, that I'm speaking only for myself, from my own experience, obviously not on behalf of the Supreme Court of Virginia. So my presentation this morning, since it is the first in this where the theme is delivering the most for your client, I thought I'd look at overall how the procedural and ethical rules shape the early stages of civil litigation to deliver the results that your client wants. So we're going to look at a few ways that these rules overlap and reinforce one another, and feel free to ask any questions. If we don't get through all of the slides, I'd be happy to make them available. And also, I think it goes without saying that this won't be an exhaustive list of all the considerations you have to consider when beginning a new case, but it should give you some ideas of the sorts of issues that you'll want to address with your client. So, as many of you will probably recall from studying for the MPRE, a lawyer has many functions: advisor, advocate, and negotiator. And as lawyers, we're responsible for providing all of these services to our clients. And I think something that often gets lost in teaching those ethics rules is that's because we're professionals. We have to provide a holistic approach to get the best results for your client. It's not going to be one type of thing that gets your client where they want to be. Professionals are different from the services that you might be able to find online, like LegalZoom. It's a relationship. It's not a one-off transaction. And that's the value that we can bring to a client's issues. So I also think that these various roles play out in every stage of litigation, but especially advocacy, and we'll see that throughout. So before you can deliver the most for your client, you have to figure out what the client wants. You need to understand your client's goals and needs, and most importantly, to understand that those needs and goals can change. So we need to be prepared to adjust as you're going through a case, or if it's a client you've had for years, don't assume that you know what's going on with them. Take the time, and as we'll discuss at the beginning in your initial client consult, to get caught up on what's happening with this client in their world. Also consider that litigation especially doesn't happen in a vacuum. If you enter into a case, it's going to affect the other parts of your client's life. If it's a family matter, obviously family relationships are at stake. If it's a business dispute, is your client going to be able to continue their relationships with key customers or suppliers if you're entering into litigation? All of that needs to be taken into account. And all of that goes into defining what the most is for your client in this particular situation. And then, not only do you have a practical duty to understand your client's concerns, their objectives, interests, you have an ethical duty too. A lawyer shall abide by a client's decisions regarding the objectives of representation. So again, we need to find out what is the client coming to us to solve. And as you can see going through the comments, the most for your client has to be evaluated given these other constraints and considerations. In particular, I noticed this part at the end that Defer to the client regarding such questions as the expense to be incurred and the concern for third persons. That's something that's in the client's wheelhouse. And you really need to have a thorough conversation with them. And as we'll discuss more when you're having that consultation and deciding whether litigation is the right choice, what are the financial constraints? Who else is going to be affected by this case if it goes to litigation? So, since we keep alluding to it, let's get to that initial client consultation. So the purpose is obviously to understand what's going on in the client's world that has brought them into your office. And that means understanding their goals and interests and taking an initial assessment of the facts. What is the story that the client is telling you about what's going on in their life? And I think the initial client consultation, we as lawyers, or at least in my experience, we tend to be the ones who like to do the talking and not so much the listening. But if at any point it was more important to listen, I can't think of one than in the initial consultation, because this is setting the stage for your entire relationship, the entire representation going forward. So once you've taken the time to understand where the client's coming from, only then do you get into number 3 here, discussing the expectations. What does the client expect of you? And also importantly, what do you expect of the client in terms of availability, communication? Where do they want to end up, and what are they able to commit in terms of resources to get there? And one thing that we always stressed in the initial client consultations and throughout when making decisions about a case and how you go forward is that you can have all the facts and all the law on your side, but once you put this thing in front of a judge or a jury, it's out of your hands. And that can be a scary thing for a client. It is a scary thing for us to admit, because we like to pretend that we have all the answers and know how things are going to work out. But I think it's important to be forthright with a client, especially at the beginning, especially to someone who's not familiar with litigation, who hasn't been through the court process before. They might assume it comes out a certain way, and it's one of your jobs is to tell them from the beginning, look, this is going to be determined by someone else. Whether we think it's right or wrong at the end is another story. Are there any other things? I don't know how many of you are involved in a civil practice or in criminal as well, I would imagine. But are there other things that you'd like to bring up in initial client consults, or reasons that you have a client consult? And actually, just for my own purposes, how many of you have been practicing for about 3 years or less? Anybody? Okay, so a fair amount. That's good. That's me too, so that's fine. We're all good. Well, one of the other things I would suggest is that this is an opportunity for some empathy and reassurance. Not in every case, but especially in family matters, or if it's someone who hasn't been through a trial before. It is, as I said, a scary time, and you are the person with some knowledge and experience, and that's your opportunity to connect with the client, empathize with their situation, and at least give them some idea of, okay, I've got someone in my corner who is going to work with me on this and get me to where I need to be. Now, some other considerations when you're starting out a new matter. Competence. Are you the right lawyer for this client? Before you even commit yourself to delivering the most for a client, there are a few things you have to consider if the person should even be a client. And that takes some self-reflection. Should you be the lawyer to handle this case? Now, that doesn't mean you have to know everything at the outset. I found this rule especially reassuring as a new attorney, that a newly admitted lawyer can be as competent as a practitioner with long experience, but you've got to work at it. And this is the thing. You can't control how smart or experienced the lawyer on the other side of the issue is going to be, but you can only control how hard you're going to work, how diligently you're going to prepare and study the facts and research the law. And that's your duty. That's what we're here to do. Now, another thing to consider, can you effectively advocate fully for a client given your other responsibilities to other clients or your personal responsibilities? These conflicts rules, which you've probably been familiar with, touch on a core part of lawyering, which is that loyalty and independent judgment are essential elements in the lawyer's relationship to a client. So you have to ask yourself, knowing your own interests and your limits, will you be unable to consider, recommend, or carry out an appropriate course of action for a client because of those other responsibilities or interests? So that's something that's on you, and you need to be honest with yourself about that because you are required to advocate fully for the client's position. Now, this is something that may come up more in the business client aspect, but when you are communicating with your client and figuring out who you are working for and making sure that the client knows who you're working for, I found this rule to be very helpful, that if you have an organization, whether it's a board of a company or a church group or whatever entity you are representing, keep in mind that you are representing that entity, that organization, not the individual people. And this is another thing that I alluded to, communication. This cannot be understated. From the beginning, you need to know how you're going to work with your client to keep them informed about what's going on in the situation. As I said, things on their end can change as the case is going on, and you may have other situations arise that need to be addressed with. So practically, how are you going to communicate with your client? What email address is good? If it is a family matter, is there an address that you can send mail to that won't be read by the other party who's involved? What number can you call? Where can you reach them? And I had a divorce client. This was in a West Virginia client, but I think it's illustrative nonetheless, who, believe it or not, did not have an email account, did not have a cell phone. So how in the world do you function in 2016 without either of those things? And we worked out that, okay, I could call his house, and I knew his work schedule, so we could get in touch that way. He worked near our office and lived further away, so it was easier to call him, have him come by the office and pick up a pleading or something to review. But here's something that we had obviously not done at the beginning, is communicating the importance of the fact that communication is a two-way street, because while we were trying to reach him, evidently he got back together with his wife. And that was the end of the case, but we did not get through to him for a few days after that fact. So that's the kind of thing you might want to flag to your client from the outset. If you have a major shift in the other party's position, let me know so we can deal with that. I can only work with the facts and information that you give me. So make them aware of that. Also, another thing is to allow your client time to review pleadings. I know lawyers tend to procrastinate, at least from my own experience. But if you can give the client time to review a pleading, make sure it's saying what they think it should say. And also importantly, it's not saying things they don't want to say. If it is, for example, a long-standing business relationship and you get a basic contract breach dispute, but you throw in business conspiracy and fraud and all these other things, and the client's long-standing associate gets this, they're going to be taken aback, and you may be putting your client on the defensive and ruining a relationship that they've taken years to build just because you didn't take the time to let them look at a pleading before you submit it to the court. So again, you might also discover that there are new opportunities to resolve the dispute that you didn't think about before because of the way facts and circumstances change. And of course, confirm the terms of your representation with an engagement letter. The rules talk about explaining your fee. Comment 2 to Rule 1.5 says a written statement concerning the fee reduces the possibility of a misunderstanding. Well, I dare say the same is true for other aspects of your representation. So lay it out in the engagement letter. Make it clear your expectations of the client and the client's expectations of you. It will make everyone's life better in the long run. So now we come to, you've had your consultation, you've discussed things with your client. Now it's time to decide, is litigation the right choice? Just because lawyers tend to be comfortable in court, just because you have a hammer doesn't mean everything is a nail. So consider, are there other ways we can resolve this without going to court? As you all know, litigation is time-consuming and expensive. So what other ways can you get the result your client wants short of going to court? Consider, is the matter subject to arbitration? And also importantly, where have you come into the case? Have there been other communications with the other party? Has your client tried to work this out? Are they close to a deal but just not there? Figure out where you stand when you come into the game. And of course, you need to be realistic with the client about those options. For example, we had a case come up with a breach of a non-compete agreement. The employees had gone to work for another company. And we sent letters, cease and desist, that kind of thing, with no response. And after discussing it with the client and being honest with them about what litigation would entail, they finally decided, you know what, now is not the right time. We're going to see how things work out and maybe decide to go that route later. And that's okay, because it's, in the end, they need to make the decision that's best for their business, and it's your job to help them get there. So the preliminary considerations, remind your client if they are going to communicate with the other party in any way. Remember what our grandmothers taught us, that you can dance like no one's watching, but email or text or whatever else, like it'll be read aloud in a deposition or attached as Exhibit A to the complaint or motion for summary judgment, because it will be. It'll end up there. So feel free to screen if you want to talk to your client about reviewing their communications with the other party. Work out what's best for you and the client, but make sure that they know that if it's in writing, it might come back at them. So if you've decided that litigation is the right choice, where do we start in preparing the complaint? Well, first thing, your case depends on the facts. You cannot effectively advocate without knowing the facts objectively. And that means we're not going to just rely on what the client told us in the hour-long consult. It means reviewing the documents, talking to witnesses, maybe there's an expert who needs to be brought in. And remember that you're also under a duty to make this kind of investigation. Rule 8.01, 271.1. If you haven't encountered this, you probably will at some point. That you are making representations to the court because it's to the best of your knowledge, information, and belief formed after reasonable inquiry. So essentially, trust but verify. You need to rely on your pleading, on documents, on other facts that can be established to write the complaint. And in doing that, you don't need to know all of the facts at the outset. There are some things that you're only going to be able to find out using the discovery tools of litigation. And that's okay. Comment 2 to Rule 3.1 says that you can, it's not frivolous because the facts haven't been substantiated because you expect to develop them later through discovery. So that's okay. That's part of using the litigation process to get what your client wants, to get the information you need to get the client what he or she wants. And of course, this should go without saying, but we need to research the law in order to write the complaint. This is why the client comes to us, because the law is our specialty. It's the means that we'll use to deliver the result that the client wants. So, I think it's also important to remember the law is not always clear and is never static. That means even if you've gone through the research at the beginning, you've drafted your complaint, you know all your elements, periodically throughout the case, especially if it's at a key point in discovery or getting ready for summary judgment motions, make sure you refresh your research. We've had cases where a case will come down and give us a new spin on a rule that turns out to be very helpful, or not. But either way, you need to know how to respond to that and incorporate it and make sure you're using the most up-to-date law as effectively as possible. The relief sought is very important. You can't get what you want if you don't ask for it. We often put, obviously the relief sought goes at the end of a pleading, so you think, oh, I just need to bang this out, get through it, and that'll be that. But don't just blow it off because you're trying to finish it. The relief requested, be specific, be complete, and tell the court and the other parties exactly what you want them to do. And that is driven by the facts that you've stated, and hopefully you've organized your facts to tell the story of why your client is entitled to the relief that you're seeking. The job of an attorney, as I've heard it said, is to help the court make the right decision for your client. This is not an abstract law school exercise about trying to figure out what the law should be or what the result would be in a perfect world. You're advocating, and you have to craft the pleading using the law and the facts to get the result and justify the relief that you're asking for. Part of asking for relief in a complaint is to plead in the alternative. You may see it as a basic breach of contract or trespass, but one way you can deliver more for your client is to realize there are potential multiple paths to get the same result or to get a more expansive type of relief sought than one single cause of action would get. Now, the good thing is under Rule 1.4, the claims and defenses don't have to all be consistent. So at the outset, you can plead alternative theories and they don't all have to come from the same place or lead to the same result. So you may plead quantum meruit as an alternative to a breach of contract claim, for example. And keep in mind that some causes of action come with types of relief that others don't. For example, you might get treble damages and attorney's fees under certain types of actions that you wouldn't get in others. So this is the time to be creative and think about how can I get the most from my client, bring in all the different types of relief that are supported by the facts and the law, and ask for them. And remember that if you don't ask for something, the court can't grant it. A court may not base a judgment or decree upon facts not alleged or upon a right, however meritorious, that has not been pleaded and claimed. And this is especially important if and when you come to appeal in a case, because a court can only consider on appeal arguments that were made below. So if you don't take the time at the outset to think through the alternatives, you may be foreclosing an opportunity on appeal as well. And some other quick considerations for preparing the complaint. Obviously, proofread. Please don't overlook that. Again, coming back to that time and planning, it helps to put it in a drawer for a day and come back the next day. Make sure it still makes sense and you don't have crazy typos in there. Using defined terms can be tremendously helpful. If you've got a lot of moving parts in the litigation and long names, shorten them so that the other parties in the court can follow you, but use them consistently. And of course, Rule 1.4J, brevity is enjoined as the outstanding characteristic of good pleading. So you don't have to beat it to death. It's okay if you get through the key facts in the law. That's all that we need to do. So, What if you're on the other side and your client is served with the complaint? Well, there are a couple things to think about. First and foremost, what is the deadline to respond? You do not want to end up in default and asking the court for forgiveness and leave to file a late answer instead of just having filed on time in the first place. And consider that you may end up having to pay other costs and the other party's fees if you do that. So deadlines matter, and keep track of how you've calculated them. I always like to put in our electronic calendar a little note, rule this said you get 21 days, they were served on this date, so it is due on this date, but that's a Sunday, so this rule says we roll over to Monday, and we're good. That way anyone who goes back and looks at it knows where the deadline came from. And you know later when you're panicking, does that deadline really, when it's actually due, okay, yeah, that's how I got there, we're all good. So the answer and counterclaim stage also determine venue and jurisdiction. This is obviously something that you consider going through the complaint as well, but especially if you're on the other side responding. This is a good opportunity to make sure that you end up in the right court. Now, your research may have told you that there is more favorable case law in a particular circuit or in a different court. So venue and personal jurisdiction are a good opportunity to get you to where there is more favorable law to get the result your client wants. So keep in mind, if you don't raise certain things like venue, personal jurisdiction, and defects in service at the beginning, they're waived. So even as you're scrambling to put together your answer or demurrer or whatever else, keep those things in mind as well. So venue options, you can waive improper venue, just accept that, yeah, this is the court where we should be, even if it's not 100% squared with the venue statutes. You can move to transfer, or the court can retain jurisdiction because there's really nowhere else to go. Same deal with personal jurisdiction. You need to check and make sure there is personal jurisdiction over your client, whether there has been effective service of process. And if there has been defective service, you move to quash. That's Code 8.01-277. But keep in mind that you waive, again, these objections if you don't make them or you engage in conduct about the merits of the case without having raised that objection. This is something else that may come up. Should you be in federal court? Again, this is something you probably looked at when you were preparing the complaint, but if the shoe's on the other foot, are you in the best court for what your client wants? Has federal case law or procedural rules made that court more appealing for the type of case that your client is dealing with? And also consider as you're going through whether the case becomes removable at a later date. Say you're handed the case and the complaint on its face isn't removable. There's some other party in there, or there's a damages cap, something that prevents you from getting into federal court. But federal case law is really good, and I really would like to be there. So keep in mind your case can become removable later, and to follow the procedures to do that. And once you remove, Rule 81 of the Federal Rules of Civil Procedure governs the time you have to file an answer. The longer of 21 days after service of the initial complaint, or whatever pleading makes it removable, or 7 days after removal, whichever's longer. So you have some flexibility there as well. In determining how to respond to a complaint, the temptation is usually anything other than an answer, because we do not want to be on the other side's page. So you have a few options, a demurrer, special pleas, but consider the strategic implications of doing that. Are you going to give away some things that you have found out about the state of the law or otherwise that the other party is not aware of? And if you give it to them at this early stage in the litigation, is that going to disadvantage your client? We had, for example, a case with a local government client, and the other party demurred and was pointing to various statutes and provisions of the Virginia Constitution. And we said, that's really interesting. And after digging a little further, realized that there were other provisions that actually said the opposite of what they had originally said, and it turned out to help us. So even though we probably would have gotten that eventually anyway, I should hope, getting that, a detailed outline of the other side's thoughts on the law at the beginning, is that going to help or hurt your client? In some cases, the demur is the way to go, but that's a call that you have to make based on the situation that you're in. And if you do file a demur or a special plea, remember to have the court suspend discovery under Rule 4:1. A lot of times, if you don't do that, it does not automatically prevent you from having to answer discoveries. So if they have served your client with a complaint and discovery requests all at once, you don't want to be sifting through discovery if there's a chance the case is going to be thrown out on demur. So make sure that you get the court to suspend discovery as well, because it's no good wasting time and resources going through discovery if there's not going to be a case. So determine also, the demur tests the legal sufficiency. It is even if we accept the facts as they are pleaded, it doesn't state a cause of action. Plea in bar or a special plea is presenting a new fact. So is there a statute of limitations issue? Is there an accord and satisfaction, a release from an earlier case? Something that is going to say to the court, you know what, they didn't talk about this in their complaint, but because of this reason, their case can't go forward. And also keep in mind that even if you go through that, chances are that the court will if it's overruled, that the court's simply going to give them leave to amend their complaint. So you may end up with just an even stronger complaint. We certainly had that happen, where in that same case of the local government, we started out with, a 10-page complaint and ended up 20-some, almost 30 pages, because they had contested every deed and everything else in the record. So suddenly it ballooned into this very thorough, case law intensive complaint, which is unusual, but that's where the other party forced us to be. So let's say you get to the plain, boring old answer. No special pleas, no demurs. In most cases, this is where you're going to end up. Just an answer. But be careful when you're responding. Obviously, a general denial of the entire plaint, that's a no-no. You have to go through the reason that they have stated all of their facts in numbered paragraphs, assuming they've complied with the rule, is because you have to respond to each fact. And if you don't deny, then they're deemed admitted. So be very careful in responding that you are actually addressing all the things that they have asserted. And remember that just because you're in a more defensive posture, or especially because you're in a more defensive posture, you are advocating in your answer as well. So don't concede points by the way that they have phrased something or characterized an event. Deny as stated, and then you can get into your counterclaim or your defenses why it is not as the other party has characterized it. But this is an important step, that you're reading critically and thinking about how and where you can dispute the way that they have presented the facts. And do not forget, when you are doing your complaint or your answer and counterclaim or the other pleadings allowed by Rule 3.8, if you're looking for attorney's fees, you have got to include the demand for your fees in the pleading that's filed pursuant to Rule 3.8, or a counterclaim or a cross-claim or your answer. It has to be in there or it is waived. So you can ask for leave in certain cases to add it later. But that is an important thing. If you're thinking there's a contract or a statute that gives you the ability to collect attorney's fees, put it in either your initial pleading or those responsive pleadings, the initial responsive pleadings. Now, in trying to get the most for our clients, if you're on the defensive posture, think about the scope of the litigation that's been presented to you in the complaint and whether your client has any other counterclaims that relate to this or otherwise deal with the same person that should be brought in at the same time. So oftentimes having a counterclaim can streamline the litigation if you've already got the other party and you're already talking about the same facts. Bring it all up together, streamline things for the court, and save the time and money of having duplicative cases. And also keep in mind the relationship between the type of response you filed to the complaint and the deadline for your counterclaim. So if you filed a demur or a special plea, motions to dismiss, you have time after the court rules on those things to file a counterclaim. So you may give yourself a little more time to develop grounds for your counterclaim if you go through one of those other responses to the complaint. So that's another thing to think about. Sometimes it takes time because you may get that complaint, the client may come to you on day 19 and their response is due on day 21. So obviously the answer becomes a priority, but you also don't want to give up on other claims that your client has. So think about ways you can extend those deadlines and leave open a window to ask for those other types of relief. If you miss the deadline to file the counterclaim, and we had this happen, you've got a couple options. One is you can have an agreement of counsel to extend the response deadline. If in that situation where you get the complaint and the client comes in fairly close to the deadline, that might be a good opportunity to call the other side and say, look, we just got this. Will you do an agreed order to extend the deadlines? And I'll run it over to the court and we can go that route. And a lot of the times the other side is okay with that because chances are they've been in that situation too. And we try and be a professional and courteous and civil bar in Virginia. So hopefully you will find that kind of behavior on the other side when you need it. If that doesn't happen though, you always have a motion for leave to amend your answer to include the counterclaim, Rule 1.8. Leave of court liberally granted in furtherance of the ends of justice, which sounds nice, but again, if you can avoid being there asking for that, it's better not to have to ask for forgiveness that way. And when you're doing that, if you file that, or you are the other party and you didn't agree at the outset to extend the response deadline and the other party files a motion for leave to amend, consider whether you really want to show up before a judge and argue that, or whether you can just go ahead and let that go. We had a case where the other party opposed granting us leave. We had to go have a hearing on that. So all the lawyers are driving to a courthouse, sitting in court, waiting to be called, and then the other side comes up and says, well, we don't consent because my client doesn't consent to being sued. I have never met the client who wants to be sued. So I don't know how you justify that to a judge. And the judge didn't quite buy that either. So we ended up getting leave to amend anyway at the expense of our time and the client's money and the other side's credibility with the court. That is an asset that you have got to protect at all costs throughout the course of your litigation. You can't be an effective advocate if the court doesn't have faith in what you are presenting to it. So we've talked about joining additional claims. You might also consider, are there additional parties who need to be brought in? Rule 312 and 313 deal with different situations to do that. 312 is more of a general approach. If in the person's absence complete relief cannot be accorded among those already parties. So let's say you have a case, your client has two neighbors, a husband and wife. The wife sues for a boundary line dispute. But your client has also had problems with the husband and wife neighbor trespassing on their land. Well, you can do the counterclaim against the wife to enjoin her from trespassing. But what about the husband if he's not already party to the suit? You can join the additional party to make sure that you've gotten the most relief for your client that you can, protecting them in as many ways as you can. So as I said, Rule 312 is kind of the general motion to join an additional party. And Rule 313 is more of the subrogation or indemnity situation where there is a person who's a party to the action who is or may be liable to the third-party plaintiff for all or part of the plaintiff's claim against the third-party plaintiff. So consider the situation you're in, which rule gives you the best way to bring in additional parties if they're needed. And again, that goes back to your client consult and in talking with your client after you get the complaint. What else is going on relating to this issue? Do you have other parties involved, other people involved, who we should ask the court to deal with while we are responding to the other side's complaint against you? All of that is an opportunity to bring it together. Yes, sir.
I wanted to raise a point regarding the idea that somebody has failed to file a counterclaim and the attorney calls you up and says, will you agree to this order? And I'm sorry, I'm not about this. I think you have a duty for jealous representation of a client to refuse that request, and you go before the court, and in order to preserve your reputation, you have to state it in terms of, Your Honor, I have a duty to protect my client, I have an ethical duty to jealously represent them, or zealously, excuse me, and I think you present it that way. I don't think you lose any stature with your judge if you do it appropriately. And I think one of the things that clients worry about most is the stability of the attorneys. And I would caution to the younger attorneys, I think one of the biggest mistakes you make in court is sitting by your friends. You bring your clients in, and then we all sit around and talk to each other like long-lost buddies. And the client's looking at you and going, who is looking out for me in this deal? So
yes.
I would challenge not challenge it, but suggest as an alternative that maybe there is a duty not to just sign off on an order. And yes, the court doesn't like it, but sometimes you win those motions. And the judge says, you're absolutely right, Mr. Hoppheimer. They had the opportunity, they failed to exercise it, and I'm sorry, Mr. Kevin, that's the way it is. So
certainly.
I think there's a duty there that I think that should be considered.
And if that had been the argument presented at court, I totally agree that we're in a different situation. And I don't think what the other party did in that case was zealous representation, because they didn't give the court any reason to rule in their client's favor. They didn't articulate that. So I think that's a good distinction to make and a good point to raise. So thank you. That is a tension that we have, because you are most likely in a smaller bar like where I was practicing in Winchester, going to be running into the same attorneys all the time. And there is a temptation sometimes to do the easy thing for you further down the road rather than the right thing for the client. So that is something that has to be taken into consideration, and you have to remember at the end of the day the duty is to the client. So make the argument, and especially if it is a case where they've delayed for a long time, then I think there's no problem saying, Your Honor, they've had months to bring this to the court. They haven't done so. They've sat on their rights. It's not in the interest of justice to go forward with this, and that's a different situation. So, and it is a judgment call. So, and it is a hard position to be in as a new attorney to figure out how exactly do I split that baby, so to speak. So, let's see. So let's say that we have made it through the initial rounds of pleadings, and now you're into the case proper. We're looking at discovery. Again, discovery is not a blunt tool. You have to tailor it to your client's objectives and the claims that you asserted against the other parties. Most importantly is, what do you need to prove in order to achieve your client's objective to establish that they're entitled to the relief that you're seeking? And you have to make those decisions in light of the client's other interests, time constraints, financial constraints, to maximize the useful information that you get from discovery to support your case and also undermine the other side. You're trying to do both things at once, build up the support for your case and take out the legs from under theirs. So based on your research, you should know what's your burden of proof. What's their burden of proof? What are the elements that you have to prove, and what facts, what documents, what information are you missing that you still need to prove, and how can you best get that? So you won't need to do the same kind of discovery in every case. You might have a form for a particular type of case, but again, each client, each situation is different. That used to drive me absolutely crazy when we dealt with a firm that you would get the same thing all the time, and it was obviously not geared toward helping their client. It was just burdening the other side without getting anything really productive done. So you can do that, I suppose. I don't see where it gets you, but try and be better than that. So if you're drafting discovery, always be thinking, how is somebody going to object to this? Or how are they going to try and wiggle out from under this? So you need to be crystal clear in your requests and figure out how to weed out as much of that in your revising as you can. For requests for admissions, use short requests that build on one another to help establish the basic facts. So with each subsequent request, you might add on another layer. John was driving the car. John was driving the red car. John was driving the red car on December 22nd, 2013. That kind of thing, so that you can see where they actually start to dispute your version of events. And that's where you can focus your attention. One thing that I found helpful is to include an interrogatory, usually at the beginning of your interrogatories, that would ask the responding party to identify any and all facts, evidence, and legal theories to support your denial of any request for admission. So they're supposed to fairly respond to the substance of requests and all of that. This is a bootstrap and suspenders approach to make sure that if they're going to deny something, they have to have a basis for it, and they tell you what the basis for doing that is. And again, like any other response, if they don't answer that sufficiently, you have opportunities to ask the court to move to determine the sufficiency of that response and possibly for penalties for not doing so. Another practical trick is that when you are doing your request for admission, consider one that says your client is entitled to the relief that they requested. Why do you do that? Are you really expecting them to say, yeah, they get everything they wanted and more, Judge? No, but if you're in a situation where they fail to respond, and this might be something that would come up, we had it especially in landlord-tenant cases if a party was not represented or had not been obeying other deadlines, you might see this as an opportunity to establish some facts and set up a motion for summary judgment and move the eviction process along a little faster. So this isn't going to be for every case. You can tailor that to the situation that you're in, but it is something to think about. And again, it forces them to respond and say, no, you're not entitled to that because of X, Y, Z. And you get to know what they're thinking and why. So all of that is another opportunity to get more for your client, more bang for your buck out of discovery. Because like I said, it is expensive, it is time-consuming to prepare and respond to. And consider what is limited in discovery and what's not. For example, you can have as many RFAs as you want to establish the genuineness of documents. So if you have deeds, if you have contracts, bills, invoices, put them all in there. Get it established from the outset, because it's not going to count against you. By the same token, you don't have a cap on the number of requests for documents. So if you have different elements of your case that you need to prove with documents, ask for them. Again, don't go crazy with 200 requests for production, because the court's probably not going to allow you to get away with that. But keep in mind that you have some more flexibility there. Versus interrogatories, say, where you're capped to 30, including subparts. So be wary of how you are drafting your interrogatories and how you're counting your subparts, because once you reach that cap, or they argue you've reached that cap, they're going to stop responding and just object to the interrogatories. So know your limits and stay within them. Now, as we said, just as in responding to the complaint and reading their version of the facts very critically so you know how to respond to them, the same goes for responses to discovery. Remember that this is an incredibly important advocacy tool as well. You cannot read anything into their requests or assume anything when you're responding. That'll just get you in trouble, and then you're playing the game according to their rule book, and that's not how you can get the best result for your client. Also, in responding to discovery, chances are you're going to have some objections. That's okay. But make sure that you actually have a defensible and specific reason for your objection. The rules require you to state your reasons for objecting, and I would encourage you to actually do that, because it's the only way you can justify to the other party, and more importantly later to a judge, why you objected in the first place. Now, as I said, the other party can move to determine the sufficiency of your objections and responses, and if there's no basis for things like, say, a denial of a request for admission, the court can deem those matters admitted. So that's another thing to think of when you're drafting them. Make sure that they are drafted in a way that's accurate, but also helpful. So if you get in this situation and they deem those responses admitted, they're ready to go, you can use them in a summary judgment motion or in a deposition or at another stage in the process of the litigation to use them effectively. And when you are making this kind of motion to determine the sufficiency, one of the best things you can do and the easiest way to show the judge why their response is insufficient is to quote their words right back at them. It is always uncomfortable to see what you have written thrown back in your face. So don't just characterize or paraphrase that they said this objection with no support. Say, in response to interrogatory 7, which stated this, they said this. And, Your Honor, there's no ambiguity in this statement because of, and give your reasons. That way they can't get away from what they actually said in their own discovery responses. And in another thing, when you're objecting, I don't know how many of you practice in the Virginia Beach, Norfolk area. I assume a lot of you are local. I have not practiced in those courts, but I would assume that there are some local rules or guidance on your objections and other things about responding to discovery. I know that we certainly had that in the Winchester-Frederick County Circuit Court. Judge Wetzel had put out a thorough memorandum. It was about 20 pages covering all stages of litigation, and he would say specific things like the objection must be specific to allow opposing counsel to appropriately respond. Vague is an objection frequently encountered in discovery. That's basically a nonsense word in the context of discovery, because we have this other word, ambiguous, and we know what that means, and that's what we should use. Well, we had other parties who did not practice in those courts frequently, and they constantly objected to things as vague. And we would say in our response to them, we would write a letter saying, this is our attempt to resolve this good faith effort to work it out outside of court without the intervention of the judge. By the way, you can't use vague in court here. That's not a proper objection under our rules. And they kept doing it. And so eventually you put it in your motion to determine the sufficiency, and you quote the judge's own rules and say, look, Your Honor, you were pretty clear here, and they can't follow the instructions. So that can be very helpful. So I think that takes me to about the end of our hour. I know that was a lot. As I said, I'm not sure if the PowerPoints will be available automatically or what, but if you would like them, feel free to get in touch with Rachel and she can get my email, and I'd be happy to send them to you. But are there any other questions about anything in particular, or as a general matter, or burning desires of legal knowledge? I don't know. One thing that I did not cover, we will be having, as I'm sure you will probably hear about later, as part of the Young Lawyers Conference effort to help young lawyers become better young lawyers, hopefully, we are starting a new series of practice tips that will be coming out available for free online in January. You'll be able to get that through our website and through our newsletter, the Docket Call. So it's going to be discrete topics, and we'll have articles about sort of a similar thing to this, where we'll go through some of the procedural and practical steps that you would go through to answer interrogatories, to start a complaint, things like that. So it's trying to be a nuts and bolts, get you started in these new tasks as a new lawyer. So that's one thing to look out for. Another thing, if you are looking for experience in client consults, initial client intake, unfortunately, as young lawyers, at least in a lot of cases, you're not the one who's in the conference room with a new client. You will be handed some notes from a partner or something, so you don't get to directly interact with the client as much at the outset. Well, the Virginia State Bar has a new online free pro bono service, Virginia Free Legal Answers.org, I believe. So that is an opportunity for young lawyers to get involved. You'll get a question from someone who is qualified under our eligibility requirements, and you'll get to see what their issue is. If you have questions to them, you can ask those questions and work with them and give them a response to their questions. So that is a good way to get involved, do some pro bono work, and also start working on that all-important task of taking an initial client when they walk through the door and figuring out how you can deliver the most for them. So I think that is about the end of our time. If there are no other questions, I think you've got a little break and then on to the next. So thank you all very much for your attention, and hope you enjoy the rest of the day.